And I'm Ellen Bach, and I'm a lawyer at Whiteman, Osterman, and Hanna. Bob and I both practice in the area of library law. We support libraries on all of the legal issues that arise for them, governance issues, policy issues, construction projects, and employment law, among many others. And we are also both employment lawyers. We work with employers of all sorts, libraries and non-libraries. We are happily here today to talk about sort of the intersection of those two practices and employment law issues that are new, particularly in New York State, at a time when everything seems new. Things are just changing so rapidly. So hello to everyone, and Bob is here with me as well. Bob.
Hi all, good to see you. Ellen, I don't know if you noticed, but we're over 80 some odd people, so we probably have to limit them to like 10 questions each. So we have enough time. So welcome everybody, good to see so many friends and familiar names out in Zoom land. It's a little strange to be doing this at the NYLA conference in this forum, but it's really wonderful to see the turnout is still there supporting the organization and getting up to date on this important topic. So Ellen, I'll let you take it away.
All right. So everyone, I'm going to share my screen and I'm going to walk through a series of slides. The way that we're going to set this up is I'll present the information on a particular topic. You'll see that we have a lot of topics all in the area of employment law. And I'm going to pause between each topic to make sure that to see if you have any questions and to let Bob weigh in, give a little color on the topic, raise issues that I have skimmed over, just to give us a little bit of back and forth. As you know, if you've seen us present before, we try to make this as much of a conversation as we can. Obviously, that's going to be more difficult under these circumstances, but let's still see if we can keep back and forth going. So with that, I will try to share my screen and oops, there we go. Okay, so I hope that everyone can see that. That's our topic, and we are going to talk about the following agenda items. First, we're going to do a quick review of some new legal issues, new this year, but that are temporary in nature, meant to address the COVID-19 pandemic specifically. And then we'll move to long-term changes that have been made in New York State employment laws this year, but that will be with us for the foreseeable future. Of course, the legislature could always change them, but they are not due to expire or meant to address only a temporary circumstance. So the first of our COVID topics is the Families First Coronavirus Response Act. And under the FFCRA, which is a federal law that was passed back in the early spring to address the COVID situation, certain private employers and all public employers are required to provide employees with paid sick leave and some expanded family and medical leave for certain reasons that relate to COVID. These provisions right now are due to expire on December 31st. And there are two different provisions, although they work together. So the first, actually, before we get to the details, I just want to reiterate the fact that the employers who are subject to the FFCRA include, for our purposes today, all public employers. None of the exceptions, which are very limited, will apply to any of you in the room. And to all private employers with fewer than 500 employees. And I want to stop just momentarily. We would typically ask the room, how many of you are public libraries and how many are association libraries? Harder for us to do that today, obviously. But I want everyone to be really noting as we go through these laws that some of them apply to public employers, some of them apply to private employers, and some apply to both. And so the first thing you should be asking yourself is, when you're confronted with a leave situation, is, okay, what kind of library are we and which laws apply for us? So this one's going to apply just, to everybody in the room, essentially, but in some different ways. So for the emergency paid sick leave that's available under the FFCRA, employers are required to provide up to 2 weeks, and that means 80 hours of paid sick leave if the employee cannot work because of a COVID-related reason. That includes being subject to a quarantine or isolation order, being told by a healthcare provider to self-quarantine because of COVID, or because the employee is experiencing COVID-19 symptoms and is seeking a medical diagnosis. So if one of those reasons applies to the employee, then the employee is to receive their regular rate of pay up to a maximum of $511 per day, or $5,110 over the entire period for which they're eligible for the leave. In addition, there is leave available, the same 2 weeks, for the employee if the employee is caring for a person who is subject to a quarantine or isolation order, or is told by a healthcare provider to self-quarantine, or is caring for a child whose school or place of care is closed or unavailable, and that includes if the child is sent home because of a need to quarantine, if those reasons relate to COVID-19. This law only applies to COVID-related reasons. With respect to the situations where the employee is caring for another person for these COVID-related reasons, the same 2-week period applies, but the employee is entitled to either 2/3 of their pay, is entitled to 2/3 of their pay, but up to a cap of $200 per day, with a total of $2,000 for the period. So there's no minimum time that an individual has to have been employed to be eligible. All employees are eligible. All employees of a covered employer are eligible. And there are a couple of, not exceptions, but areas where the law just doesn't apply. One is if the leave isn't available because the employer doesn't have any work for the employee. So, for example, if an employee has been laid off or furloughed, or if the business is closed, then there's no leave available. And the same thing is true if the employee can telework. So if you have an employee who is under a quarantine order, but can work from home, they don't get the leave. There's some other notable elements of this. An employer can't require an employee to use other accruals before using this leave. They just have an immediate entitlement to the leave. And certainly there is a prohibition against any kind of retaliation or discrimination because of use of the leave. And there are real penalties. The FFCRA includes a second type of leave, and that is an expansion of what we know as the Family and Medical Leave Act. And under this expanded FMLA, an employee is entitled to a total of 12 weeks of leave if the employee is caring for a dependent child where the school or child care provider is closed or unavailable. And the first 10 days of the leave may be unpaid, but of course, could be paid for under the sick leave provision that we just talked about. Under the expanded family and medical leave, the remaining 10 weeks leave at 2/3 the regular rate, again up to a cap of $200 a day and $10,000 in the aggregate. With the expanded family and medical leave provisions, there are some eligibility requirements. So an employee has to have been employed for at least 30 calendar days, or there's a provision that protects employees who were laid off but rehired. And again, the idea that that leave isn't available if there's no work for the employee, or if the employee can telework, is the same with this leave as well. Okay, so we're going to move to New York emergency COVID-19 paid sick leave, but before we do, Bob, do you have you gotten any questions, or do you have anything that you want to add on the FFCRA provisions?
Yeah, just quickly, I think this was clear, Ellen, but the EPLSA for the first three reasons, which are the real personal illness or treating somebody or caring for somebody who's actually got illness or quarantine, that's a pretty robust payment, because it does go up to the $511. The other thing you should be aware of out there as a practical matter, those two, EPLSA and the FMLA, enhanced FMLA, are going to work together an awful lot, particularly in that caring for the child whose school is not available to them. So, you'll see those two things interact quite a bit. And as we're going to draw a distinction in a second, this one is going to be available a lot more often than the one we're about to talk to you about. And unfortunately, because we're here in New York, you've probably heard as much about the New York benefit as the federal benefit. And for various reasons, which Ellen's about to explain, the New York benefit's really not going to control much.
So what we're about to talk about now, or we're going to talk about it right now, is this New York emergency COVID-19 paid sick leave. This one came first in terms of enactment. New York did this before the feds did the FFCRA, and so everybody paid attention to it. But once the FFCRA came into play, the New York leave became, as Bob said, much less applicable. And the basic reason for that is that it applies only to a person who is subject to a quarantine order, a specific quarantine order, or is suffering from the illness. So the federal law applies in that long list of circumstances that we talked about, including a situation where there's a more general quarantine order that applies to the individual, but is not specific to the individual. Under New York's COVID sick leave statute, the governor's office has made clear that it only applies where there is a specific quarantine, or with regard to quarantine orders, where the individual employee has been told to quarantine. So, and the other piece of it that's interesting is that the benefits are more tiered. The benefits can be much greater in terms of dollar value because you can have an employment situation, where an employee is entitled to their full pay for the period of the leave. So let's look at what benefits have to be provided. If the employer is a private employer, so this would apply to association libraries, with 10 or fewer employees and a net income of less than $1 million, there's no paid leave requirement. Those employers have to provide an employee who is subject to a government-issued quarantine order with job protection, guaranteed access to paid family leave, and disability benefits for the period of the quarantine, and wage replacement, access to PFL and wage replacement. An employee whose child is subject to a government-issued quarantine order has to be provided with access to the paid family leave benefits and job protection. And the employee can go ahead and apply for PFL or disability benefits, and they do that by submitting the request for COVID-19 quarantine leave package and giving it to the employer. But you can see it's a much more limited application. For private employers with 11 to 99 employees or 10 or more employees and a net and 10 or more employees and a net income of more than $1 million, then there is a paid leave provision. So the employee who's subject to the quarantine order is entitled to 5 days of paid sick leave and the other benefits that they're entitled to under the statute, which are essentially job protection and access to PFL. You can't charge sick leave accruals. They're entitled to this leave on top of their regular sick leave. And then private employers with 100 or more employees, which is, has limited application for us, those employees are entitled to 14 days of paid sick leave. And for public employers, the employees who, remember, they have to be personally subject to a quarantine order. They are entitled to 14 days of paid sick leave. You can give them more, but not less, and job protection for the duration of the quarantine order. And again, you can't charge their sick leave or other accruals. As a public employer, if you are a public library, you're not required to provide employees with access to paid family leave benefits because, of course, as a public employer, you're not required to participate in paid family leave. You may have opted in, but you're not required as a public employer to provide access to those benefits. Okay, Bob, anything you want to add on the New York State COVID leave?
Yeah, so Ellen, I think you and I have talked about this. We're getting a lot of questions about the interplay of these two leaves and New York's travel quarantine requirements.
Yes.
So the governor was very clear when he introduced the New York State quarantine travel requirements that he was not going to allow people to travel outside the state, which he didn't want them to do, travel to quarantine list states, and then come back and take advantage of the New York State paid leave. So he made a very big public statement that that leave would not be available to people under those circumstances, even though if you read it, you might think it did. And that remains true. And as far as I know, he has not changed his position on that. However, the FFCRA leave, the one that allows someone to take a leave due to a quarantine order or public quarantine order, does apply under those circumstances. And so we're getting a lot of questions from libraries about those two things. Which one is it? Which do I have to give? And so as a practical matter, what this does is it essentially puts you in a quandary of making a decision about how to deal with an employee who, whether you are okay with it or not, has left the state, traveled to one of these quarantine places, has come back and is now claiming a right to not be at work. As a practical matter, you come back to the question of, do I or do I not have work for them to do remotely? If you have work for them to do remotely, that's probably your best bet, because otherwise they are going to be eligible for one of these leaves. And if you're a public library, you're not going to get the benefit of the tax credit that's associated with that.
That tax credit is associated with the federal leave?
Correct.
And the other thing to keep in mind is that hopefully this will, as we approach the holidays and there may be some increased travel, the governor has changed that 14-day quarantine rule. So now there's the new testing and more limited quarantine regime. And so it at least has lessened the amount of leave that you might be required to give under the FFCRA.
There's some questions that have come up about notices and what your obligations are, and there are certainly statutory notices that you were required to comply with when these statutes came into existence and effect. And certainly if you haven't posted your posters and things of that nature, you need to do that. But if you have questions about how to deal with the very specific individual traveling out of state and coming back, you should certainly talk to somebody who's familiar with these leaves closely, either an HR professional or an employment law counselor, because there are some options, but you are limited, and what you don't want to do is deny somebody a leave that they're entitled to.
Right. So we've got the federal leave, federal COVID leave, we've got the state COVID leave, and things do keep changing in terms of how those things apply.
As if it wasn't confusing enough.
Right, exactly. And now we have, effective September 30th of this year, the New York State sick leave law. This is not a temporary law. This is not specific to COVID. This law applies throughout the state and is a long-term obligation imposed upon employers in New York. So it is job-protected sick leave. It is paid leave in most cases, but with a carve-out that we'll talk about. It applies, and here's an important distinction, to private sector employers. So many of you in our virtual room are not going to have to deal with this, but with those of you who are association libraries or otherwise subject to the private sector rules need to pay attention to this. And every employee of an eligible employer or a covered employer is entitled. So as I said, this became effective on September 30th, but there's a distinction here. What became effective on September 30th is that employees beginning on the 30th are entitled to accrue sick leave. They are not entitled to take the sick leave until January 1st of next year. So you have time to play catch up if that's what you need to do. So which employers are required to provide sick leave? It's private sector employees, private sector employers. The local governments, state governments, federal governments, including public libraries, are not going to be subject to this requirement. So the list of employees who are covered, if the employer is covered, is a long list. It is essentially every employee that the employer has, regardless of their status, full-time, part-time, temporary, seasonal. It doesn't matter if they're exempt or non-exempt, they are covered. And the rate at which sick leave accrues has to be at least 1 hour for every 30 hours that the employee works. And that starts either on September 30th. So that's what I mean when I say you'd have to play a little catch up if you're not doing this already, or when the employee starts employment. An employer is permitted to front load the required amount of leave. That means you can just provide it as of January 1st if you want to. And the only issue there is that once you provide it, you can't take it back. So if you have estimated incorrectly on what the employee is entitled to, there's no taking it back from them. Okay, so how many hours must the employer provide? Well, we've said it's 1 hour for 30 hours worked, but there are caps depending on the size of the private employer. So if you are an association library with 4 or fewer employees and a net income of $1 million or less, you have to provide up to 40 hours of unpaid sick leave in a calendar year. If you're the same size, but your income is more than $1 million, then you have to pay 40 hours of sick leave. So it's paid leave at that point. If you, and this is a more likely scenario, if you are an employer with 5 to 99 employees, then you pay the 40 hours of paid sick leave, regardless of what the net income is. And then 100 or more employees, those employers have to pay up to 56 hours of paid sick leave. So again, the employee accrues the leave at a rate of 1 hour per 30 hours worked, but it's up to these caps, 40 hours or 56, depending on size. Unless you decide to front load, you can do that and just provide everybody with the 40 hours, and you can also provide part-time employees with whatever portion of the 40 hours you anticipate they're going to be eligible for based on predictions on how much they're going to work, but you are required to keep track of their work hours, because if they work more than and are entitled to more than you anticipated, you have to give it to them. There are rules with regard to carryover and caps. So employees have to be permitted to carry over any unused sick leave from 1 year to another. Now, what's weird about that is that employers are permitted to limit the amount of leave that an employee takes in any year to the maximum amount that they're required to provide in that year. So even though an employee has to be permitted to carry over so say the employee earned 40 hours in year 1 and they used none of it. They have to be able to carry over the full 40 hours to year 2. And if they earn 40 more hours, then they have accruals of 80 hours. But you can limit, the employer can limit their usage to 40 hours in any given year. There isn't a requirement to pay out the cash value of sick leave at the end of employment, but this rule and all of the other limitations that you might put on the use of the leave should be set forth in a written policy so that employees are on notice of what the limitations are. So when can an employee use this sick leave? Anytime after January 1, but only obviously if they have the accruals or if the employer has front-loaded the time. So that's why it's important to do any catch-up that you need to do with regard to accruals between now and January 1, because the employees are going to be entitled to use those starting on January 1. They may not have all that much accrued, it's an hour per 30 hours worked, but they're entitled to take it as soon as January 1st. And there's no 3-month wait time or 6-month wait time that you can put into your sick leave policy. You can impose minimum increments on use of the leave, but they can't be less than 4 hours. So you can tell employees you have to use the sick leave in increments of at least 4 hours. But you can't, for example, say sick leave has to be used in increments of a day. 4 hours is the max. And employees have to be compensated during their sick leave at their regular rate of pay. And there are some rules that can get complicated about how you calculate that regular rate, but it's, if you have questions about that, then again, that's a situation in which to seek out assistance. You have to notify employees in writing or by posting notice before sick leave is earned of what the restrictions are going to be on their use of the leave, including those leave increments. And employees are required to provide notice to the employer, but all that the statute and the guidelines that we've received thus far say is that the notice from the employee has to be provided to the employer before they use the leave. So an employee can call you the morning of their shift and say, I'm sick, I can't come into work. If you have existing PTO or sick leave policies, and those policies meet or exceed the requirements of the new state law, you don't have to do anything more. This isn't on top of what you already do, but you need to make sure that the accrual rate is correct, that the carryover rule is correctly applied, and all of those things. So it's a check your policy situation. So the last thing on this is that there are two different kinds of leave that are subsumed within this sick leave, New York State sick leave policy. The first is sick leave and the other is safe leave. Both of these are very broadly defined. So leave can be taken for the needs of an employee or of a member of the employee's family where the employee is providing care or assistance to that person. And that's true with regard to sick leave and safe leave. Family member is defined as the employee's, and there's the list: child, spouse, domestic partner, parent, sibling, grandchild or grandparent, and the child or parent of an employee's spouse or domestic partner. And sick leave can be used for many reasons. So it's any illness, injury, or health condition. It doesn't need to have been diagnosed. It doesn't need to have required medical care at the time that the employee asks for leave. It can be used for diagnosis or care of an illness. It can be used for diagnosis or preventive care. And it can be used for routine doctor's appointments. So the concept here is we now have in New York a statutory mandate for employees to get what we think of as sort of regular old sick leave, you know, the kind that an employee has a fairly has latitude on using. This isn't like family and medical leave where there needs to be a serious health condition at issue. This is the employee wakes up feeling sick and calls in and says, I'm sick and I can't come into work. Safe leave is also broadly defined. It applies where the employee or a family member of the employee has been the victim of domestic violence, a family offense, a sexual offense, stalking, or human trafficking. And also, the employee or the employee's family member needs one of these things: services from a domestic violence shelter or other services related to domestic violence, needs to participate in safety planning or relocation or other actions that they need to take to increase their safety or their family member's safety, to meet with an attorney or social services provider, to file a complaint or domestic incident report with law enforcement, to meet with the DA's office, to move children to a new school, or to take any other action that the employee finds necessary to ensure the health or safety of the employee or his or her family member. The police don't need to have been contacted. The perpetrator doesn't need to have been convicted. This is very broad leave that the employee is entitled to take upon need. These leaves, like just about every leave we're going to talk about, are job protected. When an employee comes back from sick leave, they have to come back to the job that they were in before they took the leave. You can't reduce their pay. You can't in any way retaliate against an employee. You can't discharge, threaten, penalize, or discriminate against an employee because they've exercised their rights under this statute. And you may have no intention of doing that, but you could have an employee who you were just about to discipline for something, who then goes out on paid sick leave. You definitely want to pause, do what you can to avoid even the perception that the discipline is being meted out as a result of them having taken this leave. You don't want any cause-effect relationship there. Okay. Bob, anything about New York State paid sick leave that you want to add?
Yeah, so I'm going to just editorialize for a minute because I think there's a lot of electricity surrounding the New York State paid leave or paid sick leave. On one hand, you know, look, what we've got now is a statewide policy, which frankly, you know, whether it's from your perspective a good thing or a bad thing, it's better that it was done on a statewide basis than piecemeal, which is what was starting to happen in the state. You know, you had individual counties that were starting to pass these laws, And that was going to make it harder and harder to try and get any uniformity. So it's good that what we've gotten, I think, is, at least is going to apply to everybody. It is not, in my estimation, Ellen, you may disagree with me. I don't think this is going to have a big impact on the library community at all, because first of all, it doesn't apply to the public libraries. Okay, so you're going to continue to deal with what you're doing. To the extent that it applies to the association libraries, many of you are going to have a policy that covers most of what you have to do anyway. There are going to be a couple of areas where that's not true. So first of all, the stuff that Ellen just described, the safe leave aspect, that's new. I mean, that's a new protection that hasn't really been in place for anyone yet. And so you're going to have to make sure that your policy adopts that. And then the other area where it's likely to be different than what you're doing now is for part-time employees. And again, it's going to require association libraries to go take a pass at their policy and make sure that their policy, does something that qualifies under this statute for the part-timers. I don't think this is the big thing that people are fearful about. Now, private employers outside the library world, different story. They have some real strong feelings about it. And, I'm not going to say whether they're right or wrong, but as far as our community goes in the library community, I don't think this is the biggest thing in the world.
I agree with that. I mean, just by virtue of the fact that it doesn't apply to public employers, it's not going to affect a lot of you. For those of you who it does affect, again, just go back, look at your policies, make sure that you're complying with the accrual rates, the carryover rules, all of any limitations, and the circumstances under which the leave is available to employees, because they need to get notice of that.
So Ellen, I think you're about to switch topics and leaves for us, aren't you?
Yes, I am.
So there's one question that maybe we can field before it does. The question that popped up was, are school district public libraries subject to FCRA and or the New York Emergency COVID Paid Sick Leave? So let's just review that again. Yes, they're subject to FCRA, and we do need to comply with the FCRA requirements. Unfortunately, because they're public employers, they're not going to be eligible for the tax credit that is provided for by FCRA. They are not going to be subject to the New York Emergency COVID Paid Leave in the same way as everybody else. They're going to have to apply it across the board. Okay, so if you remember, Ellen made the distinction that public employers have to do the full 14 days. That's going to apply to the school district public libraries.
Thanks,
I don't
Beth.
have anything. Let's do it.
All right. So now we're going to talk about updates to the New York State Human Rights Law. As many of you probably already know, the Human Rights Law is New York State's anti-discrimination, anti-harassment law, and it has been undergoing change for the last few years. The legislature has really been taking steps to modify the law to increase protections for employees in New York State against discrimination and harassment. This past year was no different. There were updates to the law, and we're going to take you through those changes. So the first and sort of most overarching, and from a litigator standpoint, and both of us do handle employment litigation, is the change to the standard of proof with regard to unlawful harassment. It used to be that federal and state anti-discrimination, anti-harassment laws were the same with regard to this standard of proof. How do you prove harassment has occurred? And an employee who sued the employer had to show that the harassment was severe or pervasive. That's still true under federal law. But now under state law, under New York state law, an employee must only show that the employee was subjected to what are described in the statute as inferior terms, conditions, or privileges of employment because of the person's membership in a protected class. So remember that this is not a statute under which you've ever been able to or are now able to complain, I'm being harassed and prevail unless you can show that the harassment is because of membership in a protected status or a protected class. And those protected classes, there's a long list of them, but they include race, gender, in New York, sexual orientation, disability, age, religion, national origin. So there are many protected statuses in New York. The harassment has to be tied to the protected status to be actionable, but it now only needs to consist of being subjected to inferior terms, conditions, or privileges of employment. An employer can defend against the accusation of unlawful harassment if they can show that the harassing conduct didn't rise above the level of what a reasonable victim of discrimination with the same protected characteristic would consider, quote, petty slights or trivial inconveniences. That's an affirmative defense that the employer must bring and has the burden of proving. So once the employee shows inferior terms, conditions, or privileges of employment due to their protected class, the employer would have to come back and say, and show and persuade a court that it was just a petty slight or trivial inconvenience. So the burden is much lower on employees now to show discriminatory harassment. There are a couple of other changes on the proof issues. One is that New York state law is now explicit on the fact that an employee does not have to point to a similarly situated person who was treated better in order to make out their claim of discrimination or harassment. And an employee doesn't have to complain to the employer or file a formal grievance in order to establish liability. That's really a bigger change, in my opinion, because it used to be, and it still is under federal law, that there's an affirmative defense for an employer who can show that they made a reasonable path, policy, procedure for employees to complain of harassment, and that the employee didn't avail themselves of that opportunity to complain. In New York, that is no longer an affirmative defense. The courts may take it into consideration, but it is not a defense. So there are also changes with regard to training and policy. Now, what you may remember is that a couple of years ago, there was a requirement imposed upon all employers in the state that they provide a written sexual harassment policy and annual training with regard to sexual harassment. The law has now been updated to say that those materials have to be provided to employees in English or the employee's primary language, both at the time of hire and at every annual training. Those changes apply only with respect to sexual harassment policies and training materials. But, and this is a big but, in my opinion, and Bob, you can weigh in on this, it does not make any sense to have just a sexual harassment policy and sexual harassment training. When we do our trainings and we write our policies, we make them apply more broadly with respect to all areas of discrimination and harassment, both because you want your employees to know what their rights are and what they're entitled to complain about and how to make a complaint. And it works better in my experience, both for the employer and for the employees, if that practice and procedure is the same with regard to all forms of discrimination and harassment. I just last week had a situation with an employer who had adopted, they just took the New York State model sex harassment policy, they adopted it, they had a reporting process. But when an employee felt that they were being subjected to discrimination and harassment on the basis of race, that employee had been trained on how to make a complaint regarding sex harassment and knew that there was a policy on sex harassment, but had no idea, at least the employee said he had no idea, that there was any policy or procedure with regard to making a complaint of discrimination or harassment on any other protected status. Another change is that non-employee service providers are now protected. You may remember that that was true. That update happened a couple of years ago with regard to sex harassment. So non-employees who provide services in your library, like independent contractors, vendors, and consultants, were a couple of years ago protected against sex harassment in that workplace. Now the legislature has extended that so that the protection is against all forms of unlawful discrimination. And now the human rights law applies to all New York employers, regardless of the number of employees, and without regard, that's not limited to sex harassment as it initially was. It now applies with regard to all New York employers with respect to all unlawful discrimination and harassment. There are punitive damages available now, attorney's fees against private employers, and the limitations period for sex harassment claims is now 3 years. So here is a remaining distinction between the treatment of sex harassment under the statute and the treatment of discrimination and harassment of other types. Sex harassment has a 3-year period for bringing a claim. The other forms of discrimination and harassment are still subject to that 1-year limitations period. Bob, anything you want to add on the human rights law changes?
No, we're in our last 13 minutes or so, so I won't say much other than I think if you had asked Ellen and I about this time last year what 2020 was going to bring us, I think we would have both told you a lot more sexual harassment cases and a lot more sexual harassment litigation. I guess it's one of the few benefits of COVID because people have been doing other things and we haven't had those cases. So it's really hard to imagine how huge a change this was and how quiet it's been this year. So please, please, please don't forget these rules are out there because they really were major, major changes to the law.
Yeah, and that annual training requirement with regard to sexual harassment, that still applies.
So very quick question that came up. Was there any new legal guidance in terms of staff seeking ADA accommodations specifically related to COVID? I think all of the ADA rules apply. We have to think about those accommodation issues, but I am not aware of the EEOC issuing anything specifically different other than to say, follow our pandemic rules. And there are very clear changes in the medical inquiries that you can make during the pandemic. Ellen, anything else you want to add on that?
No, I think given our limited time, we should move on. I guess the bottom line is don't forget that as you're deciding whether someone is entitled to leave, you'll have to walk through any applicable leave requirements like the COVID leaves, New York State sick leave, the family and medical leave. When you get to all of those statutorily provided leaves, your analysis isn't done because you might have continuing obligations under the Americans with Disabilities Act and the New York State Human Rights Law to make accommodations, and the accommodations can sometimes be additional leave. Okay, New York State Reproductive Health Law, we're going to just fly through. This is a new law that was passed last year at the end of the year. Became effective, and it prohibits employers from discriminating against employees based on the employees or their dependents' reproductive health decisions. The critical thing with this, again, is just to go back and look at your employment handbook. If you have a handbook, this law specifically requires that you include in the handbook information about employee rights and remedies under this new law. There are damages available, injunctive relief, reinstatement, liquidated damages up to $100,000 of the damages award. So The state really means it when they don't want you to do this. It's not an area that I worry about a lot for libraries, except that you just want to be in compliance with the notice provisions. The New York State voting law, which you may remember changed so that, and of course we're a little late to the party on this one since Election Day was Tuesday, but we had changes to the law last year that required additional time off to vote. So employers were required to give up to 3 hours for employees to vote. And then in April, the legislature changed it back. They said, oh, never mind. And they put it back to what it had previously been, essentially, which is you have to give 2 hours to vote without loss of pay if the employee doesn't have sufficient non-work time to vote. And that's defined as 4 consecutive hours that are either at the beginning, or excuse me, between the opening of the polls and the beginning of the work shift, or between the end of the work shift and the closing of the polls. So if you have somebody whose shift ends at 5 and the polls close at 9, there's no obligation. This only applies to elections governed by the election law. And there are certain limitations that employers can put on it. You know, is it at the beginning of the shift or the end of the shift that they're going to give the time? The employee has to ask for this time not less than 2 working days before election day.
So Ellen, that one snagged me. I didn't see that get passed in the budget this year, and was just a couple weeks ago talking to somebody about election leave, and lo and behold, there it was.
Yeah, well, that happened in April in the midst of.
Yeah, it was a hidden provision in the budget.
Yeah,
and of course, everybody and their brother was trying to get the changes made. So I don't know how there wasn't more fanfare about it.
Well, the thing to know about this is that if you've got a handbook provision that says that you give employees 3 hours because you changed that last year to comply with the law, you either want to decide that that's really what you mean, you're going to give employees more time than is required by law, or you're going to change that provision back, because you don't want to have a handbook that says one thing and a practice that says something different. Okay. The New York State Salary History Ban, you may have heard about these salary history bans. As Bob was saying with regard to sick leave, we had started to see local laws banning inquiries about salary history. New York City has one, Albany County has one. This is now a statewide ban, which is great for consistency. It applies to public and private employers, and it means that the employer may not rely on wage or salary history, and that includes benefits, it's all forms of compensation, in deciding whether to offer employment to a person or deciding the salary to offer to that person. You can't ask in any way for the applicant or a current employee's salary history as a condition to interviewing or considering that person for employment or for promotion. And you also can't do an end run around this prohibition and try to get the information from a current or former employer of that person. And like most of these statutes, there's a very clear prohibition against any kind of retaliation against an employment based upon their refusal to offer the salary history, and you can't refuse to interview, hire, or promote based on the salary history, their refusal to provide it, or because they've made a complaint saying that they think you have violated the law. So there are some sort of squishy areas of this. Employers are permitted to consider information that's already in their possession. They're permitted to consider information that's voluntarily disclosed by an applicant or an employee. And they can ask about what the applicant's salary expectations are. All of these are just sort of dangerous. You know, don't walk up to the edge of the precipice on this. Just the idea here is to put salary history out of the the formulation of whether to offer a job and how much to pay. And that's all for reasons of trying to get equity in pay between men and women. That was the impetus for this. Okay, Bob, anything you want to add on salary?
The only thing I would add to that, I think, that advice is a good one, but, it's still fair game to say to someone, and frankly, I would argue this is consistent with the policy behind the law, to say, what is your expectation for salary? Because if a person is applying and has something in mind and is willing to share it, it just helps you understand what you're going to need to bring them on. But there is risk that opens you up to a question or Q&A that you don't want to go down.
Right. I mean, that's when you worry that the prospective employee will say, well, in my current job, I'm being paid X. And
did they just volunteer or not? Just that's a question that you've opened yourself up to.
Right.
So certainly they volunteered, but maybe because you asked them a question that suggested they ought to.
Right.
In any event. But be very careful in your phrasing of those questions if you're going to ask them.
Okay, and wage and hour changes that I bet most people are aware of. The minimum wage has been going up each year in New York. It has hit its cap in some places, but as of December 31st, it is going to be $15 in New York City, $14 in Westchester on Long Island, and $12.50 for employers in the rest of the state. As of January 1st, the minimum salary employers have to employees under federal law is going up, $35,568 a year. That, for the most part, doesn't have application in New York, which has higher minimum requirements. But for professional employees, it will have an impact potentially, because those who are exempt as professionals are not given the benefit of that higher minimum salary for exempt employees under New York law. That applies only to executive and administrative employees. And we've left so much time for questions. I don't know whether you have any at the ready.
Bree, do you have any questions that you want to key up?
So it looks like we do have one remaining question in our chat box, and I will ask folks to use the chat box instead of the raise your hand feature, just because we are running very close to our time limit. But the question we have is, since we have sick leave already for staff by contract in place, would you recommend changing it to PTO or sick safe leave time?
Well, I have to admit that I was just playing with my screen so that everyone could see us, even if we couldn't see them. Bob, did you listen carefully to that question?
I did, and I think if you're going to start making some tinkering, you're probably better off trying to make sure that you use the terms the statute uses, and so trying to alter PTO or create a PTO category as a solution to the sick leave problem, I think is probably making more trouble than it's worth.
All right, and I will give, all right, I got one more. So
Okay.
New York State recently passed a law that allows face shields instead of face masks as suitable face coverings. How do we protect our immune compromised frontline staff and comply with this law?
Yeah, so Ellen and I, we just had a lovely conversation about that about 10 days ago. And what we found ourselves doing, as we often do, is trying to come up with a practical solution for libraries on this. So what the questioner is talking about is the DOH just made an emergency regulation that is seemingly inconsistent with what the governor's been saying for the last 10 plus months. The reg now talks about face coverings very clearly, including cloth masks, medical masks, N95 respirators, et cetera. But it also includes as an acceptable face covering shields, plastic shields, clear plastic shields. And of course, those are somewhat protective of the wearer, but they aren't protective at all of those around them. And of course, what we're hearing from the CDC and what have you is that the value of the mask is primarily for the people around you. And so if we all wear masks, we're all protecting each other. The face shields don't do that. Practically speaking, what we've suggested libraries who have raised this with us is to have a supply of disposable masks on hand. And if a person enters the library wearing a face shield, to approach that person and say that the library's policy is to have a face covering. Here is a disposable mask. We'd appreciate if you'd wear it while in the library. Frankly, I don't think that you can force them to do it under that reg, unfortunately. And I don't know that I'd make a big hoo-ha out of it. But I also suspect if you approach someone gently and appropriately in that manner with the mask, you'll get some level of compliance. It's really only going to be the people who are doing this to make a point that are going to be your issues. Ellen, any other thoughts?
I think that's right. And the CDC guidelines are really quite clear on the issue. And so having a copy of those around, if you want to know that you've got a writing that supports your position that the masks need to be worn, it's a good backup thing to have. The CDC website, it speaks specifically to the issue of different kinds of face coverings and the value they provide.
Awesome. And I'm going to ask one more question and we will cut it there. First is a request. We've received it from at least 8 separate people. Could you please make the slides available? Lots of information and people want to have those available. So I'm going to say ahead of time, yes, we will absolutely get those from Ellen and Bob, and we will get those out to you all. And the last question is, does each employee have to be given a written copy of the sexual harassment policy every year? Or is it sufficient to give it to them when they are hired and tell them at the annual training where they can find it on the staff online portal?
With respect to the sex harassment policies, you should be making that available to each employee upon training. And the way I have done that is and I think that you want to know that you have provided each employee with a copy of that policy at the time of training. Bob, have you done anything other than that?
No, I mean, I think if you're doing a live training, you want the policy to be part of your training anyway, so you're going to hand them a copy for the training. If you're doing an interactive electronic training or video training, have the training start with a link to your local area network that has the document there, and just ask them to access the document for the purpose of the training. And then you've done everything you need to.
Yeah, you need to make sure that they have a copy of that 1 year after another. That upon hire is not sufficient, whether it's electronic or copy.
Awesome. Thank you for the answers. I think that's all we have in the chat right now. Lots of thanks, lots of just praises for covering such an immense amount of content in such a short amount of time. And again, just lots of requests for those slides. I know that some people were probably taking rapid notes on the side, so that will be really welcome. So again, thank you, Ellen. Thank you, Bob, so much for your time. Thank you to the 100 plus of you that showed up today and learned a little bit more about the changes to New York State law, including myself. So again, thank you all, and I hope to see you at another program. Thank you, guys.
Thanks, everybody. Have a good rest of the conference.